Hi everyone, I am Thejana, who is the Jurisprudence and Legal Theory tutor for the University of London LL.B at ICLS. So getting things started right off the bat, I would like to say that jurisprudence is a compulsory module in your third year of the LLB program, and in my opinion, this is one of the easiest modules for you to score if you approach your study methodically. So this module comprises of only essay-based questions alongside an analysis of a particular set case in part A of your exam, which would change every year, and actually the examiner will tell you months before your exam on what topics come tested for the part A set case alongside the name of the case. But that being said, still for all, the part A would also focus fully on an essay-based question. So let me do a small comparison for you to actually understand where jurisprudence sits in the grand scheme of things in comparison to your other modules you have studied so far. So for example, during your first and second years of study, you would have come across many case-heavy modules like contract law, EU law, criminal law, and so on and so forth. In my opinion, the reason as to why I believe that jurisprudence really stands out from the rest is because of the fact that this subject is not actually very case heavy, nor is it based on any statute and whatnot. So this is not to say that we don't have cases in jurisprudence, like we have very few, but by and large it's not case heavy. So just to get things into perspective, if not for case law, you might wonder how exactly this subject has to be approached and what does it constitute of. So let me answer that question very quickly. So this subject is actually really unique that even after a couple of months of study, it is normal if you continue to wonder and ask yourself how on earth is this subject or whatever you learn for jurisprudence relevant in the real world. And to be honest, I won't go in depth to answer this question in this short video, but I'll give you a small hint which will help you grasp the fundamentals of this question. So essentially, this subject is a bit towards the philosophical side, I would say, and as a substitute to all the case law which you would have seen in the modules that I mentioned earlier a short while ago during this video, jurisprudence would actually focus a bit more on various conceptions put forth by various theorists, as you may call them. So who are these theorists and how do they fall into the picture? So let me explain. You will actually come across various people or theorists, as you may call them, like H.L.A. Hart, Ronald Dawkins, Joseph Raz, Hans Kelsen, just to name a few. And this subject would be more focused on their conceptions or the ideas that they put forward. So at this point in time, if you're a third year student, you would have heard the phrase by your tutors who have gone on to say many times that law essentially has no right or wrong answer. And while I will not go on to debate that at all costs, I would like to say that this point of law having no right or wrong answer drills more in deep or more in depth when it comes to jurisprudence. Because, when it comes to the other subjects, there are certain elements that the examiner expects you to include in your answer and a certain direction they want you to go in. But when it comes to jurisprudence, there is literally no right answer. You can go in any direction that you wish. For example, if I give you a set answer structure and you write something entirely different from what I have given you, you can even score a distinction with your answer. So this is how unique the subject is. So just to give you a very small taste on what is to come in jurisprudence, this module will focus on, for instance, how the law has been fundamental in oppressing women, something that we will actually go on to study as feminist legal theory. We will even look at aspects on how things like the working class is oppressed by the rich and powerful in society, which is a fundamental area of Marxism. And amidst all of that, we will look at more philosophical questions, like I mentioned earlier, such as where actually law gets its validity from. Because we are always used to, looking at law as something that is not to be questioned. And if law is there, then we say law is law. That's it. But what if we actually go to question, from where law comes from, what gives it its validity? You will basically find many conceptions such as the rule of recognition, the good norm, which will actually go on to answer this in their own different ways. So you will come to understand that some theories, like Hans Kelsen for that matter, go on to actually give give validity to revolutions, such as military takeovers as seen in the Taliban takeover of Afghanistan as of late, provided certain criteria are of course met. You will even come across legal principles such as no man shall profit from their own wrong, and you will see basically how many of these principles, despite not being written or codified anywhere, how they play a key role when judges actually decide a case. So this is just a small gist of this super interesting subject, but I do hope that this video sheds some type of light on what this module is about. So thank you and wishing you all the very best.